I guess it all comes back a lot of times to the strategy. I'll give you an example. When I was a partner in one of the big firms in Israel before I started my own firm, one of the clients came by and they filed a U.S. provisional patent application for him, and then after a year, a PCT. And by the time we got to the national phase, we asked him, okay, what countries do you want to file your patent application? And he said, oh, I have a ski mask, so a camera for a ski mask, so I need just 2 countries. So why did we go through all of that? I mean, a waste of time, a waste of money, but they just do it sometimes almost automatic, offering people, you know, the kind of same patent applications. So this client didn't need all of that. We could just have filed in these 2 countries up front and saved him all of that. So it all comes back to the strategy. Another aspect of the strategy is doing the right balance between trade secrets and patents. The client sends you everything, but some of the things you don't have to put inside, you don't have to include in the patent application. And you can tell the client, okay, this you can keep as a trade secret. The clients need us as their attorneys to tell them that. They don't know that. Many times they're not aware of that. Or sometimes they would keep information from us, which we need for the patent application. So it's always very, it's a sensitive balance. Also, if a client is going to file a patent and a design, one could be cited as prior art to the other. So sometimes you would want to file the design and the patent application at the same day or in different countries on the same days. So this very sensitive strategy has to be done at the start. Also grace periods, you know, in the US there's a 12-month grace period, in Israel only for designs. All of these type of things need to be upfront. So it all comes back to the strategy, synchronizing the different type of patent applications like a utility model or US provisional, and then synchronizing all the IP type of protections. Also synchronizing the IP with other fields like privacy, okay, privacy by design. Okay, when a client starts developing his software, you might want to just tell him to pay attention to this side as well, because we've had clients a lot of times, developing a product, getting a patent, and then they decide, okay, we can't use this because it violates privacy issues and stuff like that. Also, taxation issues many times when they do assignment of rights of patents. So there are many, many other aspects that we as attorney are not always experts in all of these aspects, but we do have to raise them. We do have to tell the client, okay, pay attention to that as well, check this as well. And they expect that from us. So I guess these are the main things that I have in mind regarding strategies.